Should a state court be able to tell a Christian university who they must have on their board, even if those board members are of a different denomination? Now the religious identity of the university is at stake. Hi, I'm Peyton Luke, and you're watching First Liberty Live. The very religious identity of Bethesda University is at stake because the government decided to get involved and tell the university who they should and shouldn't have on their leadership board and who they can have as appointees. So joining me today is Jeremy Dye, Senior Counsel here at First Liberty Institute, and he's going to unpack all the details and explain the story to us. So Jeremy, thanks for joining us today.
Thanks for having me.
Of course, it's always a pleasure. So Bethesda University, their leadership had an internal dispute, and then the government eventually got involved. So take us back to the beginning of what happened and how everything got to this point.
Yeah, at its heart, Bethesda University, they have a governing board like every organization should that has a nonprofit like this. And there was a faction that got onto the board that probably should not have been there. They had a different religious belief than the commitments that the university has. And the board itself said, no, you're not able to be seated here, and you may think you are, but you're not allowed to. And so they voted to remove them from the board that they didn't have any right to be on in the first place. Well, that faction then sues the organization sues back, and at this point the court should have just said, this is not what we do. This is not what federal courts, in this case, not what a state court is supposed to do. And should have exercised perhaps some judicial humility to realize, hey, we're not supposed to be involved in making these decisions as to who's religious enough to be on this board, and should have walked away and allowed them to settle their dispute on their own. But it didn't. Instead, the court decided that it could make a decision based upon, quote, neutral principles. That's a kind of a legal term of art that we can get to later on, perhaps. But decided to make that determination and said, no, these individuals were allowed to be on this board after all. Well, Bethesda then appeals that to an appellate court. The appellate court agrees with that determination. Then they appeal that to the California Supreme Court, which decides not to hear the case at all. And we've now taken that case over to take it all the way to the Supreme Court of the United States for the very simple proposition that the individuals who are aggrieved by a decision of a religious institution ought not to be allowed to appeal to a state court to make a decision that they disagree with. Otherwise, it could ruin the entire character of a religious institution.
Sure, that should be dealt with on the inside by that leadership board. That's why they're there after all. So some people might say, listening to this case, well, these proposed board members, they're already Christians, so what's the issue since they're part of, a different denomination? Like, what's the issue? So therefore, I want you to speak to the concerns and the potential loss of foundational identity if Bethesda was to be forced to include these board members.
Well, the concern is the state courts or any state official looking over the shoulder of this religious institution and determining, well, they're religious enough and so they can be on here. No, that's a determination the organization itself gets to make. It's not a decision that can be second-guessed by the courts, and shouldn't be second-guessed by any politician for that matter either. In this case, it is the judge that's making that determination, that the judge can stick his nose into the business of the university and say, well, they're religious enough. And just take it into the context of a church, for instance. Let's just say that a Presbyterian church in this hypothetical decides to oust some members because they don't confess the faith correctly. Well, those members then sue the church to get back into it. Is the court going to go through the Gospels and determine whether or not they've confessed the faith correctly, that they've been baptized in the correct manner, with enough water, without enough water, whatever it might be? Is that the role of the court? Well, of course not. That's not what a court's supposed to do. That's what elders of a church or religious leaders of a denomination or religious institution is supposed to decide. Same thing here. It's not the role of a court to determine whether or not these individual factional members are religious enough to qualify for board membership. That's the decision of the organization itself. And while it may leave a little bit of a dissatisfaction that they can't appeal to a court to have that matter settled, that's okay. We should be happy that they would be able to resolve this on their own, whether that's through a mediation or through an arbitration agreement or just simply sitting down in the room together and resolving the matter on their own. Courts are good for a great many things. They're not good for this situation when you've got religious entities sort of sparring against one another and are appealing now to a secular court to make a religious decision. That's not what we want in this country at all. And that's exactly what we've asked the Supreme Court to say. There's case law now going back to 1871 where the courts have been warned to stay out of these religious discussions and not make any religious determinations. It's a doctrine called church autonomy. If you want to get really formal, it's called ecclesiastical abstention. And it's the same doctrine either way, just telling the court, stay out of the business of the discussions of how religious people need to be a part of your religious institution.
So I know it's going to come up in the comments, so I'm just going to get ahead of it. How does the separation of church and state apply in this situation, or does it not at all?
Well, it's the actual correct use of the term separation of church and state, right? We want to separate the church's decisions from the state's decisions. The state can serve an appropriate role in times to be able to solve disputes between people about property and a tort law and even First Amendment issues. But it's not the role of the state to come in and to solve issues of pure religious substance. And that's what's going on here, where the state is now imposing upon itself the title to be able to come in, or arrogating to itself the opportunity to come in and say, no, these folks are religious enough, they're theological enough, they're whatever religious stripe Bethesda is enough to be able to be on this board. That's an organizational determination. If you have a Southern Baptist organization, for instance, do we want them to come in and say, well, those Methodists can join on here because they're Baptist enough? Well, no, of course not. That would be silly. Or the same thing if you take it to a different context. You have a Jewish organization. Are we going to say, well, we're going to allow the Presbyterians to join the Jewish organization because, well, they're Jewish enough? No, that's not a determination that a court is ever supposed to make.
I can only imagine how many churches would be upset if that started to happen. So I want to go back to something you said earlier, neutral principle. Expand on that for us.
Yeah, neutral principles. So there is an exception to this doctrine of church autonomy, which says that if you can make a decision based upon neutral principles in the context of a property dispute, then perhaps the courts can make a determination. And that's what this court attempted to do. It attempted to port over that doctrine from a property dispute and say, well, I can look at the bylaws or I can look at the contracts and I can make a decision with neutral principles as to if they're religious enough. That is sort of a self-defeating conversation if you think through that sentence long enough. The neutral principles doctrine just simply said, well, are there metes and bounds that we can look at? Are there title documents that we can look at to determine who actually owns this property? That's purely neutral requirements. That's a very simple discussion to be had. Determining whether or not someone is religious enough to serve on a board, well, it takes it out of the context of any sort of neutrality whatsoever and straight into the doctrine of church autonomy, which is exactly what we told the court is the problem here.
So why does this case matter, and why should people care about it, even if they're not connected to a church or to a Christian university? Why does this matter?
Well, it matters to every local church, every local synagogue, every religious institution that you may be part of, whether that's a denomination, a church, a house of worship, or your favorite charity, because we don't want the state telling you who you must have on the board if they don't share your religious commitments. There's a reason why people of faith get together to do things that they don't do on their own, whether that's a house of worship or a religious charity. They get to make that decision as to who organizes their community, who defines their community, who leads their community, and it is not appropriate for the secular courts to second guess those decisions. And that's nearly a direct quote from that case back in 1871.
So what is the legal status of this case, and then what are the next steps?
Well, we just filed the cert petition at the Supreme Court of the United States, and so now it goes into that lengthy process of the other side making an answer. Perhaps we'll get some amicus briefs that will support our petition, urging the court to take the case on. And then we'll find out whether the court wants to simply say, no, that was wrongly decided, and we're going to, it's called grant, vacate, and remand. They would just simply say that lower decision was wrong and it should have been this. Or if they're going to grant some argument time to, more briefing and more argument time at the Supreme Court to determine this very important issue and give some more clarity to the doctrine of church autonomy. We certainly hope that will be the case, that there would be more added clarity around the country. There's some reasons we've listed in our briefing as to why that would be appropriate right now, to give every organization and, of course, every court in the country more added clarity as to what it means to have this doctrine of church autonomy in our back pocket.
Is there anything else you would like to add or you think that would be beneficial for our viewers to know regarding this case?
Yeah, look, you can always read these cases, and as lawyers, we hope you'll actually read our briefing at firstliberty.org, and to remember that not every single court remembers that important doctrine, even if it's going all the way back to 1871. From time to time, it requires the Supreme Court to weigh in and say, you know what, this is an important issue that we're going to remind all of our lower courts that they have to follow as well.
Well, Jeremy, thank you so much for your time and for your work on this case. We'll be following along with it.
My pleasure. Thanks so much.
Awesome. Well, if you would like to find out more about this case or any of our other cases, as Jeremy said, be sure to check out firstliberty.org. And if you would like to look for our press release on this case, you can go to the news tab and scroll down to press releases, and you'll be able to read all the different details. So thank you so much for joining us today. First Liberty, fighting for what matters most.